Thanks so much for attending. We appreciate it. We put this seminar together as a kind of an overview from both the perspective of the entrepreneur in the States or foreign resident of the States, looking to invest in the States or potentially move to the States or benefit children in the States. As a contrast, we're also going to talk about some of the US entrepreneurs and investors who may be looking outside the country for structures and tax work, and also take a look at how that compares to their options in the States. On the agenda, we have a lot of slides, so we'll stick to mostly the high points in 50 minutes. We'll go through why we would choose from an asset protection perspective certain jurisdictions in and outside the States. We'll go through some basics on veil piercing. In other words, when we choose an entity, we want to be insulated from the liabilities and problems associated with that operation. That's the veil. And we want to stay behind the veil. We don't want any veil piercing out to the owners or operators of an entity. We'll go through LLCs, which venues to use, some of the single member LLC issues, etc. And we'll do something similar with trusts. A lot of people confuse LLCs with trusts. We have a variety of options of both onshore and offshore. And then we'll do an overview of some of the taxation, which is radically different with respect to US people, US citizens and residents versus offshore citizens and residents. And we may talk a little about the SCOTUS. The Supreme Court has updated the tax law a little bit over the last 12 to 24 months, and we can hit the high points of that as well. In terms of the asset protection side, we have no interest in hiding or running from anyone. What we do as lawyers is we create a structure unrelated to the tax side of things, in many ways unrelated to the convenience and corporate side of things. We want to take into consideration how protective the structure is. So if we're running a US operation and we feel like we have some personal exposure or the entity has exposure, we may want to put assets into an offshore structure or an onshore structure where if we run into litigation, it's very difficult to reach those assets. Someone would have to spend a lot of time and money to even consider breaking through that structure to get those assets. Basically, we look at titling, which is how do we own the asset? In other words, these is individual titling in general, not entities. Some states allow for tenancy by the entirety, for instance. Some offshore jurisdictions, which were governed by the UK, also allow for tenancy by the entirety because the idea comes from the old dowry, the English dowry, where dad would give assets to daughter, as a dowry to get married, but didn't want new husband to take off with the assets, so they had joint title. They both owned it together. What that creates, and we have that in Florida, most of the states on the East Coast still have tenancy by the entireties, is what that is. That if one spouse is sued, the asset is not available. If both spouses are sued and become liable to the creditor, then the asset is available. So it's not an ultimate, it's not a silver bullet, so to speak, but it is very protective by having this joint titling in this tenancy by the entirety. That's one example of titling. Exempt assets, exemptions here, are assets that by state law, residents of Florida, residents of New York, have certain exempt assets like the 401k, the IRA, certain life insurance. Interestingly, those exemptions, even with respect to the same assets, can vary wildly. In Florida, the owner of a life insurance policy on him or herself, that's an exempt asset. That asset is exempt from creditors if the owner is sued. But if you buy a policy on somebody else, the value of that policy is not necessarily exempt. So these cross-purchase arrangements, some people are falsely under the idea that that's a protective asset. It's not. If someone's sued and they own a valuable life insurance policy on someone else, that can be reached. So you have to be careful to research the quality, the strength of that exemption. We use also trusts, typically spendthrift trusts. Trusts are the idea of in the 15th century, dad goes off to war and leaves assets for child with someone else, with brother. So you put assets with a trustee for a third party. And what you do with that is you split title. So if brother, the trustee, is sued, those assets are not available to the creditor. If the kid is sued, who's the beneficiary of the trust, those assets are not available to the creditor either. So you've taken legal trustee title and beneficial title with the beneficiary and split them out such that you create the trust fund baby. So the trust fund baby gets in a car accident. Well, he's going to show this trust beneficiary interest of, $100 million, but because the baby can't get to the money, neither can the creditor. And that's how trusts work, domestically and offshore. Trusts are also an English creation. You'll find that if you do business in a non-common law jurisdiction, you often won't have the ability to do the fideicomiso, the trust. So you would have to find another means of asset protection in general. And then we deal with entities, business entities. Now we principally have the LLC. We use the LLC in combination mostly with the trust and titling, because the LLC offers both inside and outside asset protection, and we'll get into that in a second. There's the TVE I'd mentioned, and trust can be, you can have a domestic asset protection trust and a foreign asset protection trust, which we'll get into. Historically, if you wanted to create a trust, you had to do it for someone else. So in Florida, for instance, if you created an irrevocable trust for someone else, like a child, no, if someone sues a child, they can't get to the asset. Someone sues a trustee, they can't get to the asset. But the statute specifically says you can't do it for yourself. You can't say, hey, I'm going to create a trust for myself and appoint a trustee, and no one can get to the asset. 20 states do allow that, and that's an asset protection trust. And offshore, there are several jurisdictions, and we'll get into some detail on that. One thing we want to deal with the international entrepreneur, whether we're dealing with an investment offshore, business offshore, or someone coming in, we want to choose the right entity, which does not allow for veil piercing in general. In Florida, we have very strong veil piercing protection. What that means is something that goes on in the business of the entity. We don't want the creditor, if someone falls down in a shop or on a property, we don't want that creditor to be able to reach outside the entity, pierce the veil, and sue the owners. That's the last thing we want to get into, right? In Florida, it's very difficult to do that. Essentially, you have to disregard the entity and you have to utilize the entity for an improper purpose. For years, we had this highlight case where these guys were doing a valet service for highlight. They had a different entity, but it said highlight on their shirt or whatever. It looked all the same. And so those guys crashed into somebody and they didn't have any money. So they sued Dania Highlight. Dania Highlight says, well, that's a different entity. So that's not us. And they won. And they won because they respected their entity and they weren't using the entity for an improper purpose. There are your three elements, which is this alter ego. You kind of use the entity like your own piggy bank, and that it's used to defraud for an improper purpose. Obviously, the improper purpose has to cause harm. And so in Florida, it's very strong. In many states, it's very strong. It's very hard to get out of that structure to the owner. And that was really one of the first forms of asset protection in the states, where we are allowed to create a corporation, and that corporation can operate for its proper business purpose. And what happens in the business is not the problem of the owners. They're not liable for what occurs in the business. Now, of course, you sign a lease. If you sign a personal guarantee to that lease, or you take out a line of credit and you sign a personal, you're liable. You're liable. Otherwise, you wouldn't be. That's why they have it. Of course, you have professional liability, lawyers, doctors, architects. If they do the work, they do the work in the entity, they're personally liable, which is a well-known exception to that. Fraudulent transfer is something else. That's what that this became an issue recently in Florida, where if you have a company and you're kind of shoveling out assets to the owner, the plaintiff can go get those assets. That's not a piercing the veil claim. That's just I'm going to go get those assets because you moved them out to avoid the creditor. But there's no damages for that. So typically that the plaintiff is going to want to create a piercing the veil claim on that. You use the entity for the wrong purpose to distribute those assets, and then there's no limit on the damages. So obviously you avoid exposure by funding properly the business. Don't move anything out while you've got a claim or you owe money. Very basic stuff. Maintain solvency in all your insurances and do business in the ordinary course. A lot of times we can also combine it with estate planning and structuring and make it even stronger than just piercing the veil with a corporation. That being said, we've kind of moved entirely to LLCs. So along with the idea that the LLC doesn't require annual minutes, it's very easy to deal with. It is harder to set up in a way, in the sense that there are no bylaws for LLCs. There's an operating agreement, and you really have to know how to draft the operating agreement. There was about a decade of litigation on poorly drafted operating agreements. It was great for the litigation people because people would kind of grab a form and then start operating these big businesses. They had no idea what the form said, and they get into litigation. We had a number of matters like that. But what's the advantage is, if you can get it done right, it's very flexible and you can kind of move the LLC exactly to what you want for business purposes. But more significantly, it has inside liability like a corporation, where what goes on in the entity doesn't spread outside to the owners, right? The piercing the veil. And it has outside asset protection, which means if someone sues an owner, they can't get inside to the assets. With a corporation, you sue the owner, you take the stock. There is no protection for a corporation at this point, unless you think you're going public. There's no reason to have a corporation, guys. If you want to discuss that, my contact info will be at the end of the seminar. But there's really no reason to have a corporation anymore. There's no tax event to convert it to LLC status. It's just you get the outside protection. Someone sues an owner, it's much, much more protected. And this is kind of the background history of how LLCs developed. We couldn't do an LLC for years in the 90s because it was subject to the corporate tax. So we had these LLPs and these LLLPs, and it became like a silliness circle. And they eventually just converted that all to LLC. They got rid of the corporate tax. And now we have the inside and outside protection for the LLC. And that's the way to go. In Florida, we have a problem with the single member LLC, which we'll talk about in a few minutes. So someone coming in, right, looking for an LLC, not a single member, not going to go with single. We've seen that a few times. Someone going out, well, we may go to Nevis, West Indies, do an LLC, single members allowed and protective. I had penned that section of the Nevis LLC statute. So you have to kind of pick your jurisdiction. If you have a jurisdiction where you're where you live is very weak, don't use that jurisdiction. It's possible that you can use a Delaware or you can use a Nevada. Delaware is anonymous, which is nice. Um, get the protections you want. And then the risk is, well, if I have a litigation in Florida, they may apply Florida law, which is doesn't make sense actually legally, but it has happened. Well, that's better than having a Florida single member LLC, which you think there's pretty good likelihood that's just going to get foreclosed and lost. So you want to be careful with choosing your state jurisdiction or your offshore jurisdiction. This is related to what's called the internal affairs doctrine. So Florida, for instance, has the internal affairs doctrine where if someone forms an entity somewhere else, Florida says, well, we'll respect the internal affairs of that entity. What that means hasn't really been defined. Does that mean that that charging order remedy, that limitation on someone taking a equity in an LLC applies? We don't have the case yet. But it's better than saying, hey, I'm just going to go for a single member in Florida and take my chances. That's not a great idea. Here's some other internal affairs, statutes of limitations, trading. And then, of course, we combine jurisdictions depending on who offers the best option. We have a few cases on the choice of law issue. We've got the Barber case. It's Wells Fargo versus Sabrina Barber. That was a wild case. That was really a fraudulent transfer case, but that's the case where I had mentioned she kind of was running away from Wells Fargo. She had defaulted on some debt and was kind of shoveling assets all over the place, which is just idiotic. But the idea is that the court said, no, I'm not going to rule on a fraudulent transfer, which seemed to me the right cause of action. I'm going to say there was money put into a Nevis LLC. I'm going to say that Nevis LLC actually is a Florida LLC. And the Florida single member LLC is not protected. Yes, that's what they did. So you have to be aware of the fact that the courts will often go off the rails to protect a creditor, especially in this idea where they're running away like that and there's a breach. The opposite is like this JP Morgan case where they had litigation in Arizona. The defendant had assets in Colorado. So instead of staying in Arizona and trying to collect, the plaintiff went to Colorado to collect against those single member LLCs. But if you go to the jurisdiction where the LLC is formed, the court will very likely uphold the strength of that jurisdiction. If you think about that, you rarely do you want to go as a plaintiff to the jurisdiction where the LLC is formed, unless it's just a very weak LLC, because the court will uphold it. If you're in a jurisdiction or you can bring the defendant to a weak jurisdiction and claim, no, 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 we should go under this weaker law, that's usually more effective. So the Colorado court said, no, not going to happen. You can't get in. This is a case, the Shim case is an interesting case. We had a case in Florida where you had a judgment against a defendant who claimed, well, I know you want these entities, but the stock certificates are in United Arab Emirates and Dominican Republic, and that's the jurisdiction that should govern collection. And the court went for it. That was the Sargent case. So the court said, I'm not going to hold the defendant in contempt, which means that actually the court can put the defendant in jail under civil contempt until they disgorge the stock certificates. I'm not going to do that, the court said, because you can go to Dominican and United Arab Emirates and take your judgment and sue there and get the stock certificates. Of course, by the time they get there, the stock certificates are in, Liechtenstein. So that was very, very debtor friendly. That was later overturned by the Shim case, which said, no, no, we can put you in jail until you bring back the Korean certificate of deposit. And now the Sargent case is overruled by the Florida Supreme Court. So you can't just say that the certificates are not here, so you can't get them from me. These are all factors when we look at where to invest, how to structure it. Are we going out of the country? Are we coming into the country? Super, super relevant. This is the same idea where you always are going to face this idea of civil contempt, where the court can put you in jail if they see assets and you claim I have no ability to reach them, like they're in a foreign trust that I created 3 hours ago. That's not going to work. They'll put you in civil contempt. Longest now is Lawrence, which isn't on here, is it? No, it's not on here. Similar to Grant. I was a 6 years on a bankruptcy. Arroyo's is an interesting case where you had litigation in Maine and there it was resolved. There was a the creditor, the plaintiff came down to Alabama to collect, and the court said, well, wait a minute, like I'm not going to rule on a Delaware. So you had Maine, Alabama collection, and a Delaware LLC. I'm not going to rule on a Delaware LLC, which is fascinating. Don't have any idea what they were even thinking, but it goes to show you that if we stay out of the jurisdiction, like for instance in Maine, if they would have claimed in Maine, they probably could have had some kind of collection through Maine because that's a pretty weak jurisdiction. You go down to Alabama, Alabama said, I don't want anything to do with it. And now what? Now they've got to go to Delaware. Delaware is going to uphold the strength of that LLC. And that's probably what happened. It didn't go any further, I don't believe. So if we go into single member LLC, so a lot of times we're dealing with a foreign holding company that's going to create single member LLCs in the States, for instance. As we'll note in a few slides, if we have someone abroad and they want to invest in the States, we don't want to create an estate tax issue because there's very little exemption to estate tax. So we have to create a foreign entity, right? Now, if we create a foreign entity, we're typically going to put, for instance, properties in LLCs in Florida or wherever they're buying them in the States. We have to keep in mind that the single member LLC in Florida is pretty weak. We had an original bankruptcy case. This Inree Albright was a movie star and she went to bankruptcy, which is usually a mistake. Bankruptcy is, if you take anything from it, bankruptcy is essentially a mistake if you have assets. So if you own anything and it's valuable, you typically don't want to go through bankruptcy because what's going on is you're requesting the discharge of indebtedness. So there's this huge debt. You need it to go bye-bye. But you kind of have to give up your assets. There are protections still to keep assets, but the courts typically really have tremendous power to reach assets for instance, public policy reasons, etc. And you've been given a discharge. It's usually a mistake. In her case, it was. So that was the single member deal. The court reasoned, well, this whole idea of protecting an LLC comes from the partnership law. You don't have a partner. We're taking your stuff. It was followed through in Florida. They went through the exact same analysis and kind of completely disheveled the entire LLC statute in Florida. I think that was like 2013 or something. 2012, I want to say. And so they had to redraft the whole thing. But they did redraft it better, but they still expose a single member LLC. Yeah, so we typically go with Delaware or Nevada. Wyoming has a bad case. You generally want to stay away from Wyoming. And then we don't know how the courts are going to react, but we do have some insight into like someone who sets up a 99 to 1% LLC, right? And we have a California case where the court basically said, you know, you owe this creditor $5.5 million. You've got $178 million or something in your family holder, and you've completely shut them out. And it's kind of a 99 to 1. You've got all of these other entities and you've decided not to make a distribution. So what happens is if you have a claim against a multi-member LLC and there's no tenancy by the entireties or no trust, you can lien that equity. You can't take it, but you can lien that equity. And so if there's a distribution that's made, you can take the distribution. But of course, people don't make a distribution once there's a lien. So that's what Baldwin was saying to Curchi. Like they were, it was probably negotiation tactic. Like, hey, you can lien me up, but I'm not going to send anything out. So I'll give you $4 instead of 4 million. So that's where they were at. California had an odd case that did not allow for reverse piercing the veil. In other words, taking equity like that. But the court said, no, no, this is ridiculous. He controls everything. He makes all the calls. He basically is solely controlling and owning this structure. It's kind of like a single member LLC. There's really no other member. We're gonna allow the plaintiff to make that claim and send it back to the trial court. So you don't want to make it too onerous. You want multi-member, multi-manager. You want trust for the kids in there for 5%. Make it look real. Once it starts to not look real, it's very tempting for the court to break it. And then many courts have just upheld it as is. There's the Glick case, which was basically multi-member with a trust. And then, so we'll get into trust here. Let me make sure we have time. Yeah, we got it. Where we have weaknesses with the LLC, either offshore or onshore, we want to blend protections. So one thing that's very common is when we create a multi-member LLC. So if we have husband and wife and we're not sure if that's a single member, we don't think so. But in Florida, it looks like it's a multi-member, but we're not sure. We add trust for the kids. Add trust for the kids, put your brother as trustee. It's a 5% interest. It's real. It's irrevocable. They file their own tax return. It seems like a winner. What happens when you can't do tenancy by the entireties? In other words, you have a single person, they may have kids, but they're not married. So if they get into trouble, if the surgeon leaves the sponge in, the surgeon's single, you know, he's subject to charging lien. So he gets in a problem with a malprac or a car accident, he's subject to charging lien. We want to eliminate the charging lien because otherwise you can't get any distributions out of the family entity. So what we do is a self-settled asset protection trust. We hold the surgeon's interest in his or her asset protection trust, and that makes the charging lien difficult. So you blend the protection. That's onshore, and I'll tell you why we would do an onshore for a foreign person in a second. We'll get into what happens with respect to funding a foreign trust. These are some of the additional advantages of doing an offshore LLC. A lot of times we do offshore LLCs to segregate assets. Like if we have a trust with a lot of assets and we think there may be liability associated with a property, for instance, we'll just drop it into its own LLC and kind of insulate it off. With respect to offshore planning, we always use an offshore trustee. We like to have an offshore manager. Everything's that's the advantage of it being a U.S. person using offshore entities. The advantage is the U.S. court has no jurisdiction over those entities. They're extremely protected. Offshore person using offshore trust also has its advantages. Here's a self-settled trust offshore, same idea as the domestic. And here's the trust in general. Is really a tax move offshore. A lot of times it's really a tax move, which we'll get into. So why are trusts so protected? Why can we put one on top of an LLC and actually there's no charging lien? Because the trustee has legal title, not involved in the litigation. Those assets are not available to people suing the founder of the trust. We're not talking about revocable trusts in general. Revocable trusts are a fancy will. Every week someone comes to us and says, well, I have a trust and it's protected. Revocable trusts are a fancy will. There's nothing wrong with revocable trusts if you want a will, but they do not create any protections. These self-settled trusts started offshore, essentially it was a money-making venture, really. So you have all of these British holdings that say, okay, you can form your own trust, and under our law, it's protected. Whereas in the States, until late 80s, you couldn't do it. You couldn't do it. So that's why you have all these foreign asset protection trusts that are very, very protective. In the States, it's only you have 20 states now that offer it under different rules. And this is the vehicle that we use on top of a family LLC or business LLC a lot of times to prevent that lien. So if someone sues the owner, we can prevent the lien by putting the equity into an asset protection trust. We can't do this in the middle of litigation. We don't want to abuse it. That's completely a mistake. But now we have 20 jurisdictions. Typically, we would use Nevada or South Dakota. They're very strong. But if you live in one of these jurisdictions, it's probably also very strong. Being a resident of the jurisdiction with a trustee in the jurisdiction, very strong. I'm in Florida. We do not have one. These are some of the factors that you would look at when deciding on where to set up a self-settled asset protection trust. It is largely untested. We do have several cases now. Um, these are bankruptcy cases. I had mentioned it's very uncommon that you want to go bankrupt when you have assets. In Uber, it was a developer who set up an Alaska trust. It really was okay. It was more or less, they kind of did the minimum to set up the Alaska trust. They did have an Alaska co-trustee. It seemed legal, but they went bankrupt. And when you go bankrupt, the rules that apply to breaking through these entities completely change. So Uber did not really have much of a connection to Alaska, and they used that to apply the law of your residence, which was Washington State, which did not protect the trust. In Mortensen, you had someone who lived in Alaska set up their own Alaska trust, looked pretty good, actually. Um, he got sued on several matters, including divorce, and the suit was not within the statute of limitations on fraudulent transfer. In other words, it was in general too late for those creditors to get anything out of the trust. It had happened too long before their claim. But he filed bankruptcy. He opened up the statute of limitations to 10 years. And on a 10-year claim in bankruptcy, all your assets are available. Not a great idea. Trustco was a similar statute of limitations issue where Trustco was owed money and Trustco was advised you can take away from the case, advised of the planning. So if your assets go into a protective structure domestically and you tell the creditor or the lender at that point, they only have 4 years to make claim to assets within the structure, and they didn't. And that's what the court went to. The court did not get into the substance of the statute. It's just that they didn't make the claim on time. So Matthews got to keep their assets. There's some other rules. If you go to, for instance, Alaska, you have to be very careful about the strict compliance with some of their disclosures. Obviously, it can't be a sham. You can't create a trust that's not filing its own tax return, or if it's a grantor trust, you really have to insure assets in the trust. You should use a trustee in that jurisdiction. You really can't do a sham or anything like that. You can't go crazy in court like this guy Stillman did. You don't want to. tempt the court. Hey, everything's in a trust. You can't get it, blah, blah, blah. They cracked through his trust. Still don't really see the logic in that case, but they did. Um, and of course, like I mentioned, you still want to segregate the underlying assets. Do we go foreign or do we go domestic? Well, if you're US, your consideration is, do I want the Full Faith and Credit Act to apply? So full faith and credit means if I have a judgment in one state, I can apply it to any other state. I can go collect in assets in any other state. Well, that doesn't apply offshore. There's no Full Faith and Credit Act. So if you have a Nevis trust and your assets are offshore, you've got to go take your judgment from the U.S. and domesticate it in wherever those assets are. That may or may not work. Nevis is very difficult. That's much more protective. Whereas if I can do it in the States, it's quite a challenge. We have defended those asset protection trusts in the States, but it's an endeavor. This is some of the benefits. We're going into some of the benefits of the foreign trust in an older slide, but it's very, very protective offshore. But the key is that it's not in the jurisdiction of the U.S. court that's making the judgment. You want to we can aid the client in most of the selection of the trustee compliance. There, we have several CPAs on the line. I understand many international CPAs do all the FATCA and FinCEN requirements. There is more to deal with, but it's really a CPA function. And this is kind of, the end of the trust LLC side. If there's any questions, just post your question. Be happy to answer. Well, we still have a good 10 minutes or so. Um, here's some more cases, same idea. This is this alter ego. Obviously, we're dealing with professionals mostly here. We're not going to have abuse of these structures. We're not going to pretend there's something else. That's obviously always a mistake to do a sham. We're going to trick people, this kind of thing. Always these things are exposed. We actually very rarely encounter it, and we really don't handle any kind of clientele that gets into that. So let's get in. Let's do a little bit about some of the tax. The tax tail often wags the foreign dog. So if we have an offshore group that wants to invest in the States, it's often a tax issue more than an asset protection. In the States, it's often an asset protection issue more than a tax issue because of the way the tax law works, and obviously because of our out of control litigation in the States. So if we look at the estate tax for the US citizens and residents, this is why people don't come in. Everyone seems to want to come in, honestly, now. Um, it's this worldwide taxation by the US. So many of our families and many partners in a number of businesses that we represent offshore want to come in, but don't come in because they're utilizing different jurisdictions for different tax plans that they just can't do in the States. They may get a credit in the States, but if you're in the States, you pay worldwide estate and gift and income tax, right? Very onerous, can be very onerous. There's a $15 million exemption, so every dollar above that is taxed at 40% if you're a US person. And the same is true, gifts above $19,000 reduce your exemption. The gift is obviously per item. The estate tax is a whole shebang. Foreigners, there's no marital deduction. It's a common mistake I see all the time. There's no marital deduction between foreign people. So if you have husband and wife that, for instance, for whatever reason, bad advice, we just had one with a mansion. They bought a mansion in the US and mom died. The tax attaches immediately. So the idea is not to buy things directly in the US because it's subject to the 40% tax and you don't get the $15 million credit. It's a brutal, brutal outcome, but it's very easy to avoid. So when we decide who's subject to worldwide taxation and who's just subject to taxation in the US, for the estate tax, it's a domiciliary or citizen. What's a domiciliary? Someone who comes to the US with the intention to stay in the US. Whereas with income tax is what most people understand as and incorrectly understand this to be applicable to estate tax, but it's just income tax. It's based upon the number of days in the state. So your substantial presence, which is essentially more than half a year over an average of 3 years. And that's the 120-day rule that every single Brazilian citizen knows. So you can stay here up to 120 days and you're fine. You're not a resident for income tax purposes. Here's the problem. If you stay here, even if it's less than 120 days and you want to stay here permanently, you want to live here forever, you're a US domiciliary. You're subject to worldwide estate tax. And then we get into, as part of the play, sometimes we make a gift, sometimes we don't complete the gift. This comes into play with mostly Americans. I've got here, we're still doing US citizens and residents. If we don't complete the gift, we're not subject to gift tax, but the asset remains in the taxable estate. So, but if we go to non-US persons, right, on the income tax side, that's the substantial presence test. What are the exceptions? Well, you're taxed on US source income coming out of the US, unless you've got a treaty or unless there's an exemption, right? So there's no tax on the sale of intangible property. There's also no gift tax on the gift of intangible property. So you can sell it or gift it. It's a significant advantage for people who want to buy and sell stocks and bonds in the US. But be careful. You have to do it through a foreign entity, which we'll get to in a minute, to prevent estate tax on death, unless you give it away. So you may have a treaty which will reduce the rates. That's mostly Europe. We have Asian treaty, but essentially nothing in South America. There's a 30% withholding on income that's passive, like rents and interest. However, with interest, you can often get that entirely tax-free and also from a bank account. So you can lend and get a bank account interest tax-free. Foreign trusts are taxed as independent foreign entities, and they have their own scheme of income tax. And if it's not sent out to the US beneficiaries, it accumulates, and there's an accumulation tax as well. On the estate tax side, basically, it's very onerous because there's no exemption. It's only $60,000. But we want to give away intangibles tax-free. We want to take advantage of the treaties, right? And we want to create a blocking entity. So we can do the debt, the portfolio debt, which will not be part of the estate, take advantage of treaties. But really the way to do it is to implement a foreign holding company. If we implement a foreign holding company and we're non-domiciliary, right? Which means we live abroad, we're gonna stay abroad. We're not really subject to estate tax except on our US assets. There's no worldwide taxation. We live abroad. Only in the US. We create a foreign entity, taxed as a corporation generally, and that entity holds all of our accounts and properties in the States. That's it. That's it. If you do that, there's no estate tax. If you don't do that, you're going to exceed the $60,000. Yeah, $60,000 exemption, and you're going to be taxed on 40% of the value when you die. You have to create the foreign blocking entity. It's very straightforward. Once you have it, You can open up bank accounts, you can buy property, you can do whatever you want. And you can even in the States have a little Delaware holder or Florida holder, and that can hold bank accounts and properties if you want to insulate the different properties, etc. But you have to own it through this entity to stop the estate tax. It's also very easy to move, by the way, the foreign to a foreign holder, U.S. stocks and bonds. The real estate is a little more tricky. There's very specific rules on how to move real estate because real estate is not considered a tax-free capital gain, even if it's in a U.S. entity. So it's a little trickier. There are regs on it. It can be done, but stocks and bonds, you want to get those into your foreign blocking entity. Also the real estate, but it's a little trickier. This is an interesting issue I like to bring up on people that are non-domiciliary. They don't intend to stay here forever, but they're here for a while. So you got to be very careful. So if you're here and you're here more than the substantial presence, the 120 days, let's say, you now are treated for income tax purposes as a resident. So as a resident, you now are subject to these regimes that say if you've got an entity offshore, which you have to have for estate tax purposes, you're going to have to comply with the controlled foreign corporation and PFIC issues, which is a hassle. It's an issue that a lot of people miss. You got to keep that in mind. And then you can ameliorate that. That's really like a whole seminar in and of itself, and I don't want to go too far afield. And then when we create these foreign trusts, it's fairly significant for US people too. So if we're a US person and we fail either that a US court can't control the trust and it's like or we have a foreign trustee. If US court can't control or we have a foreign trustee, it's a foreign trust. So at that point you're going to have to comply. You're going to have to tell the IRS what you have. And then it'll be considered disregarded for income tax purposes while the grantor is alive. So it's usually US for asset protection purposes. It's disregarded for income tax purposes. If there's a US beneficiary, there's almost always a US beneficiary. So it's like it's not there for income tax purposes until there's a death of the grantor. Upon the death of the grantor, all the assets are deemed sold, which could be brutal because of the capital gain tax associated with that. So you can either bring them back into a domestic trust if those assets are not in the estate. If the assets remained in the estate, in other words, someone dropped them in there for themselves, there was no completed gift, and the assets are in the estate and get the step up in basis, there's no problem with the deemed sale. But if you did actual gift tax planning and the assets are out of the estate in a foreign trust, you've got some planning to do because if there's a death, there's a deemed sale. If you've got a foreigner and a foreign trust, it's kind of a different format where it's respected, but the game with the foreigner is if you've got foreign beneficiaries, people who are in Europe or South America that aren't coming here, and you've got US beneficiaries, right? Do you make distributions? How does that work? Well, what you want to do is you want to form it as grantor, which means it's disregarded. So the grantor will pay all the tax on the U.S. source income. The grantor will handle all assets and distributions and then can give away as an individual distributions to the U.S., distributions abroad. The people abroad don't pay any tax. And they don't pay any tax at all on foreign to foreign distributions. So if you've got a foreign trust and you have foreign beneficiaries, those foreign assets just float outside the US net and can be distributed out. If it's grantor, even the US stuff the grantor pays and then can gift back to the US people. They have to tell the IRS that they got a gift, but there's no tax. That's the ideal, this grantor foreign trust. It's kind of difficult though because you have to set it up under certain restrictions where it can be revocable or it just benefits the grantor and spouse. There's detail, but it's really, you can overcome most of the detail. This is where we have people that move to the US after setting up a foreign trust. Essentially, if you move to the US after you set it up, you become a US person who just contributed to a foreign trust, and you're subject to that deemed sale unless you have a US beneficiary, and then a deemed sale at death. So you can domesticate it. There's some options. We have an article on that if you'd like that. I think we're going to wrap up if there's any questions. This is how foreign trusts act. Typically, it's the foreign trust it acts like a foreign individual. Treaties are very, very helpful at times in Europe and some in Asia where they'll reduce the rates for you. I don't want to spend too long because we're kind of out of time. And there's quite a bit of compliance. Here's your 3520, which all the grantor, the trustees, and the beneficiaries match through this form. And if you get a foreign gift, you've got to file the 3520. And we had a few new cases. Essentially, the first one is Connolly, where now we know that if we have a buyout by an entity of a partner that pays with life insurance, that life insurance is included in the value of the decedent's estate. Very careful with that. And I can answer any questions on that. You want to use a cross purchase arrangement to avoid that. We've got more, which says that the mandatory repatriation tax, which taxes years of reinvestment in foreign entities. If you reinvested, you weren't taxed on income of a foreign entity that you controlled or Americans controlled. You've got to pay the back tax under the prior um, the prior Trump regime enacted that. And then we have Loper Bright, which basically says that the courts used to have to follow regulations if there was an ambiguity in the law. So that administrative regulation was very, very powerful. Now they don't. They don't have to follow the regulations. The court can decide. It's very powerful. We're just now starting to see cases. We have one case now where one of the parties is arguing, no, we don't have to follow that reg. We need the court to decide, and I think they're going to win it. And there's my contact information if you need it. We appreciate you attending very much.